Good afternoon, Ms. Bridgewater. How are you?
Good afternoon. How are you?
Doing well. When is the SAP reset date?
The 23rd of March.
Thank you.
Mhm.
Okay, it's right at 2 o'clock. Good afternoon, everyone. When everyone's ready to go, courtroom 2 will be ready.
Good afternoon, Your Honor.
Good afternoon.
I got to get my calendar ready, but
Okay.
we're gonna start with Mr. Patrick Harney. I see he has a private attorney, Mr. Greg Willis.
Okay. What position is that?
Position almost.
Good afternoon, Your Honor. Greg Willis here for Mr. Harney.
Good afternoon.
No, this one.
Let's see.
And Your Honor, I'm here
Number
present.
nine.
Position 9, I believe.
Brittany Dudley.
I'm sorry, say it again, Mr. Willis.
Your Honor, I'm here and I'm present with Miss Brittany Dudley. She's the alleged victim in this case.
Okay, thank you. Good afternoon, Mr. Harney. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir. Yes, sir.
Thank you. You have been charged in case 23 CR 001400G with battery family violence. Your history, Mr. Howard?
One moment. You see that?
Okay, yes, I do.
All right. He got 12 arrests, suspended license that's open out of Cartersville, and a DUI, on probation in Glenn County for reckless driving, Whitfield County false statements or writings, battery, reckless conduct, and the CWAC charge. 2016 possession of marijuana and possession of drug-related objects. That's it.
Okay. Who's representing from the state?
Your Honor, George Agbe for the state.
Good afternoon, Mr. Agbe. You can proceed.
Thank you, Your Honor. The facts of this case are as followed. The offense date was March 9th, 2023. This incident took place on 1000 Park Avenue, Northeast Atlanta, Georgia. The officers were called out by the victim in this case, who's my understanding is present in the courtroom or is on the call. And we would ask that she have opportunity to speak if she so chooses. According to the victim, she conveyed to the officers that they were coming back from having drinks, and that an argument ensued as they arrived at their apartment complex, that the defendant got upset and that he then pushed her, causing her to hit the ground. Officers observed blood coming from her nose and mouth. We've gone over his criminal history, Your Honor, but he does have prior batteries convictions, one from 2017 from out of Whitfield County. He also has several drug-related or DUI-related offenses, and as it seems in this situation, that either something, alcohol or drugs were an influence in this case as well. He was a primary aggressor. He was arrested, Your Honor. So we just want to put all those facts on the record, and also ask if you want us to go into our recommendation. Or
Yes, please.
Your Honor, that we would be asking in this situation that it's the one count of battery, Your Honor, family violence battery. They do live together. That we ask for a $6,500 surety bond. No contact with the victim, to stay away from that location, the apartment location, and while under supervision, no alcohol or drugs. Also, that he would complete an one-day anger management course.
Okay. Mr. Willis?
Your Honor, we are asking for a reasonable bond in this case. Mr. Harney has hired me to represent him. We will certainly address these charges when the time comes, and we will certainly make all of our court appearances. Miss Brittany Dudley is here with me, and she's requesting that it not be a no. She does not want a no contact provision in the bond. She wants contact with Mr. Harney. Mr. Harney actually lives in this location alone. She lives in Canton, Georgia, is where she's located. She does stay with Mr. Harney from time to time, but does not live in that particular residence. And she's here. She came here voluntarily to tell the court her position is she definitely wants Mr. Harney to have a bond, and she definitely wants contact with him. And I understand that's going to be the court's decision, but we do want a reasonable bond in this case to address these charges, and we'd ask for a bond of $2,000, Your Honor.
And this is Miss Brittany Dudley that's with you here.
Yes, sir.
Okay, can you raise your right hand for me, ma'am? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, ma'am. What would you like to tell the court?
That I do want contact with him and bond.
Has this ever occurred before?
No,
Are you afraid of him?
not at all.
Okay. Anything else, ma'am?
No.
All right. If nothing further from counsel, it's going to be a $3,000 good bond, no further violent contact with Brittany Dudley, and no drugs, alcohol, or weapons while out on bond. All right. Good luck to you, Mr. Harney.
Thank you very much, Your Honor. I appreciate it.
All right. You all have a good day.
Thank you. Can we be excused?
Yes, sir.
Thank you, Your Honor.
Who do we have next?
Next, Your Honor, we're gonna go to Mr. Austin Marshall. He also has private attorney, and he's position number 12.
Good afternoon, Judge. Emily Evan on behalf of Attorney Phil Price representing Mr. Marshall.
Okay, good afternoon, Ms. Evan.
Thank you.
Good afternoon, Mr. Marshall. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 23 CR 001397F with simple battery family violence. Is there a history, Mr. Howard?
Yeah, first adult arrest.
Okay, good afternoon, Ms. Duncan.
Good afternoon, Judge Morrow. This incident did occur on March the 6th, 2023 at 134 Cold Creek Drive. The victim in this case is Catherine Marshall. That's Catherine, CATHERINE, Marshall, common spelling. Officers were called to this location in reference to a dispute. Once they got to that location, they spoke with the homeowner, Mr. Gary Fleming, who informed that his daughter, Miss Marshall, had been staying at his house with her children. He stated that the defendant and Miss Marshall are married. However, they've been living separately with no formal other court filings or court orders in place. Mr. Fleming told officers that the defendant in this case entered the vehicle that he shared with Miss Marshall and attempted to drive off. And Catherine told the defendant in this case to leave the car and to get off the property. And she took out her phone and began to try to record what the defendant in this case was doing. He had become visibly upset and aggressive. He exited the vehicle and approached her and smacked her phone out of her hand down to the driveway. By the time officers arrived, he had already left the scene. However, Catherine did provide officers with the video she took of the encounter with her husband, and officers did indicate that that video showed the defendant approaching her and smacking the cell phone out of her hand while she was recording him. Given the circumstances, Your Honor, we do have some concern about the risk of offense, given that there seems to be some tension between this couple, given that they are married and currently living separately. We do have some concerns about intimidation of this particular witness. I don't believe that we were able to make contact with her. However, we would like the court to sound for her. Given this defendant's limited history, we are going to be requesting a $2,500 total surety no further contact with the victim in this case, a third-party child contact, a stay away from that incident location, which was already stated on the record, 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. I did want to note for the court that although this is the defendant's first adult arrest, he does have a juvenile arrest for terroristic threats from 2006, which is allowed to be considered by the judge under 1511-703. Nothing further from the state.
Ms. Everett?
Thank you. Good afternoon, Judge. As the state indicated, my client has no prior arrests on his record. He has no history of threats or violence towards this particular victim, alleged victim, who in this case is his wife. He has significant ties to the local community, lives in the community, and has no failure to appears or anything of the such on his record. The parties are, just for some background, the parties are going through a divorce. It has been filed very recently. This alleged incident occurred sort of right around the filing of the divorce. Both parties now have retained counsel, so that should alleviate any need for the parties to communicate about anything other than the divorce and about their minor children. The parties are living separately, each, I believe, with their respective families. There should be no other reason for Mr. Marshall to have to go to that residence for anything other than dropping off or picking up of the children. There's no indication or any allegations that either of the minor children were involved or present during this. So we would ask, our biggest concern, judges, is to make sure that we ask the court not to include the children in any no contact provision. He desperately wants to see and talk to his children, and I think part of the allegations here that arose were based on some failure to communicate about the children's well-being. Hopefully that will all be resolved in the divorce case, but that sort of I think is how we got to this point. We would be asking for to permit unsupervised nonviolent contact with the children involved, their years of birth are 2019 and 2020. We are asking to prevent nonviolent contact with his wife only for the purposes of coordinating child pickup and drop off, which we will anticipate being handled in the Superior Court divorce matter. And we are requesting a minimal bond based on his lack of history. Judge, we'd be asking for a $1,000 bond.
And we'd like the court to sound for the victim, and since we weren't able to speak to her, it would be the state's position that we'd have no further contact with the victim and third-party contact for the children.
Catherine Marshall, if you're on the line, this is now your opportunity to address the court. If you would like to, if you are on the line and would like to address the court, you'll have to unmute yourself, activate your camera, and I'll have to swear you in. Ms. Everett, your client has his hand up.
And Mr. Marshall, I would just encourage you not to make any statements at this time. Today's hearing is solely about whether or not you're granted a bond in this case and how much. It's not about whether you've committed any acts or actions. It's not about guilt or innocence. So I would just ask if you have questions for me that we speak after the case is resolved for today. Is that okay?
Yeah, it's not necessarily a question. I just wanted to add a point that we do have an arrangement in place that my mother is going to be the intermediary between the kids.
Okay.
So there will be zero contact with Catherine and I. That's been agreed upon.
And we have no objection to that, Judge, as far as the state's request for an intermediary.
Okay. As such, it's going to be a $2,000 signature bond through the jail. No further contact with Ms. Marshall.
Excuse me, Judge, I'm sorry. My attorney does have a provision that I'm allowed to text her about only children pickups, and that's it.
Okay, so at this point in time, Mr. Marshall, there's going to be no further contact. You're going to have a third party to go between, as far as I of course would not keep a father from his children or a mother from their children, but I don't want you having any contact with Ms. Marshall at present. And no contact means absolutely no contact. Okay, so
and does that override our standing order currently in place?
It does, Mr. Marshall. I will answer all of your follow-up questions. I promise you. Just let the judge get through his ruling. Okay.
Okay.
Thank you. Let's see. And no drugs, alcohol, or weapons while out on bond. I'm giving you a signature bond, Mr. Marshall, but you're going to have to make sure to come back and answer to these charges. Otherwise, they're going to put a warrant out for you. Okay.
And I'll receive a court date, I assume.
Yes, you will.
Yes.
Okay. Yes, Ms. Duncan.
Just to clarify the court's ruling, that's 2,000 signature through the jail with no further contact with Catherine Marshall, third-party contact for child visitation, and no alcohol, drugs, and weapons. Will the court be granting a stay away from the incident location?
Who's living at that location?
It's indicated to us that Ms. Marshall was at that location with the children.
Okay, well, if Ms. Marshall is at that location, then of course he's not going to be able to go to that location. So stay away from Ms. Marshall's home address. Also, I don't know if he needs a one-time escort to retrieve any belongings, Ms. Everett. But
Not to my knowledge, Judge, as I'd indicated earlier, the parties have a marital residence, but neither of them are staying there at present. They're both staying with their separate family. So it's my understanding that this incident allegedly occurred at her family's location. We have no need to return to that residence.
Oh, okay.
It's her father's home, Your Honor.
Okay, well, all right. Anything further on Mr. Marshall?
Nothing further from the state.
I guess,
Mr. Marshall, I promise I will answer all of your questions after court, okay?
right.
Thank you, Judge. If we may be excused.
Yes, have a good day. Thank you.
Thank you, sir.
Next, Your Honor, we have position number 8, Ms. Vanessa Hunt, position number 8.
Okay, thank you. Good afternoon, Ms. Hunt. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. You've been charged in case 23 CR 0014003F with battery and cruelty to children in the 3rd degree. Is there a history, Mr. Howard?
2013 ag assault, 2017 trespass NOLO, 2018 theft of lost and mislaid property NOLO. And she has a warrant out of Fayette County, forgery in the 3rd degree.
Yes, Mr. Agbe.
Thank you, Your Honor. Your Honor, this offense took place on November 29, 2022 at 943 Trestle Tree Court Southeast and 800 United Avenue Southeast, Atlanta, Georgia, 30312. Officer responded to the above location. I met with the victim in this case, Ms. Hines. I haven't had the opportunity to speak with the victim in this case, and I'm trying to see, I don't believe that she's on the call, Your Honor. But Ms. Hines indicated to officers that the relationship between Ms. Hines and Ms. Hines, they were exes, and that on this day that Ms. Hunt got upset and punched her in the face. Officers observed blood coming out of her mouth and also what they described as have a busted lower lip, and that this incident took place in front of the victim's minor daughter. There is some fear of reoffending, as there has been some other violent previous convictions. There was an aggravated assault out of DeKalb County that was resolved through first offender that was successfully completed. There also, as stated earlier, there's an outstanding warrant out in Henry County. There was a criminal trespass out of Gwinnett, ended in a NOLO. That criminal trespass also had a no contact provision as well. So there is that fear of reoffending. There's a fear of also intimidation of witness, seeing as that there was a romantic relationship between the two. With all that in mind, Your Honor, the state would be asking for a $5,500 surety bond, $5,000 on count 1 and $500 on count 2. No contact with the victim, a stay away from the address, 1 day of anger awareness, and while under supervision, no alcohol or drugs, no weapons as well.
Okay. Ms. Kim?
Yes, Your Honor. Miss Hunt is actually 32 years old, and she was born and raised here in Georgia. This is her hometown, and she is gainfully employed at Papaya at the fast food restaurant as a kitchen cook. However, she works only part-time. Thus, her financial means is not really good. She is qualified for public defender services. So we will continuously help her to take care of her one child. There is another child that complaining witness has, but they don't live together, And my client resides with a totally different place with only her child. And it is completely okay to have a stay away and no further contact with a complaining witness. We would like to request for signature on bond. If possible, no further violent contact will be the best. This happened last year, and I try to reach complaining witness because she is not afraid of my client. They're still dating, even though they don't live together. They are actually in the relationship yet. So we would like to sound for complaining witness. Thank you.
Is that the complaining witness's last name?
Your
I don't
Honor,
know who.
the complaining witness, his last name is Hines, Your Honor.
Okay, that's what I thought. Is Ms. Hines on the line? And it's my understanding that neither the state nor Ms. Kim has spoken to Ms. Hines. Is that right?
I
Yes,
cannot be sure, Your Honor.
Okay. So at the present time, given that no one has spoken to Ms. Hines, for the cruelty, it's going to be $1,000 good bond. For the battery, a $2,000 good bond, making a total of a $3,000 good bond. No further contact with Ms. Hines. Stay away from the Tressler Tree court address and no drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
All right. Good luck to you, Ms. Hunt.
Thank you.
Ms. Kim, you can call courtroom 2. Mr. Shannon is waiting by the phone. And next, Your Honor, we're going to go to position number 1, Ms. Catherine Bennett.
Okay. Good afternoon, Ms. Bennett. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Good afternoon.
Thank you. Good afternoon, ma'am. You've been charged in case 23 CR 001388D with battery. Is there a history, Mr. Howard?
Second arrest, 2009 assault. That's it.
Okay. Is this your case? Good afternoon, Mr. Young.
Good afternoon, Judge. Yes, Your Honor, this is my case. This incident happened on March 4th, 2023 at 4071 Hammock Trace in Atlanta. Hammock, common spelling. The victim in this case is Daniel Perez. Daniel, common spelling, Perez, P-E-R-E-Z. Officers responded to this location and made contact with the victim. He advised officers that he had returned home. He had been out drinking. That's when Miss Bennett, along with another individual, assaulted him, caused the laceration. He told the officers that she and her daughter, it was her daughter, that was the other individual, they jumped him. They were there to get some belongings from this incident. We have not had any contact with the victim. However, the state is concerned that the offender has a propensity for violence based on the previous arrest and this incident occurring. They are married and legally separated. The victim stressed to the officers that he was concerned about the defendant possibly. He stated to the officer that he would defend himself. So I believe that insinuates that there was some concern that she may try to reoffend. So the state's recommendation is a $3,500 surety bond, no further contact with the victim, stay away from this address, no alcohol, drugs, or weapon, and 1-day anger awareness. And we would ask the court to sound for Daniel Perez if he's online.
Okay. I see Mr. Perez there. I'll give him the opportunity to speak in just a moment. Ms. Cook, are you representing Ms. Bennett?
Yes, Your Honor, I am.
Yes, good afternoon. Would you like for Mr. Perez to speak first, or would you like to address the court first?
You can allow Mr. Perez to speak. I just sent him the link Zoom information, so I've spoken.
Okay. Mr. Perez, this is your opportunity to address the court if you would like to do so. If you would like to do so, I need for you to unmute yourself, and I'm going to have to swear you in, okay?
Yeah, no, I'm not sure that he's, oh, there you go. All right.
Okay.
Hello?
Yes, can you hear me, Mr. Perez?
Yes, I can.
Okay, can you raise your right hand for me?
Yes.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes. Yes.
Okay, thank you. You can put your hand down, sir. What would you like to tell the court?
No, me and Catherine never had a problem before. It's just something that happened. I'm really not looking for anything. I don't need her to stay away from me or anything like that. I truly, she's not a bad person at all. And whatnot. This was a one-time thing. I could even take some of the blame. And I just, she needs to just be, she's never done this before in all the years I've known her.
And you're not afraid? You're not afraid of her?
I'm not afraid of her at all. No, sir.
Okay.
No, sir, at all. Not at all. I know her, her kids, family, we're very close and whatnot. So no, not at all. I can just guarantee that there was a one-time thing. I know because I've even spoke to her after and whatnot, and we spoke, and no, sir.
Okay, thank you, Mr. Perez. We appreciate you being here.
Yeah, she's a very good person, Your Honor.
Okay. Ms. Cook?
Yes, Your Honor. Miss Bennett is 42 years old. She does have one child who she's the primary caretaker of, a daughter who does have medical issues that need to be addressed very soon. She is a high school graduate. She also is a food truck owner. Her job is boomtastic affairs. She's been owning this truck for about 1 year. As pretrial mentioned, she does have a 2009 arrest, but what you didn't hear was a conviction. My understanding is she does not have any prior criminal convictions. She is innocent, obviously, unless and until proven guilty, and she does maintain her innocence in this case. Your Honor, given her age and no prior criminal history, and the fact that the victim is not afraid of her and does want contact, we will be asking the court for a signature bond and no further violence or harassing contact with the victim.
Okay. It's going to be a $2,000 signature bond through the jail, no further violent contact with Mr. Perez, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Bennett. And we thank you for being here, Mr. Perez.
Your Honor, I was just informed that position 15, Michael Shannon, is going to take a pro se plea. I've sent the paperwork over to courtroom 2 for that defendant to go over.
Okay. So if you all will assist by getting him to do the paperwork, Norris would appreciate it.
I got you, Your Honor.
Thank you.
Next, we're gonna go to position number 3, Ms. Lakeisha Davis.
Okay. And you're free to go, Mr. Perez. Ms. Davis, good afternoon. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. You've been charged in case 23 CR 001389A with simple assault family violence and simple battery family violence. Is there a history, Mr. Howard?
I got first arrest.
Okay. Mr. Young?
Yes, Judge. This incident occurred on March 8th, 2023. The victim in this case is the defendant's daughter, Kiara Harris. Officers responded to 400 Griffin Street, Northwest in Atlanta in reference to a domestic dispute. Ms. Harris advised officers that her mother, the defendant, Lakeisha Davis, had entered her room and started yelling. When Ms. Harris began to record the incident with her phone, the defendant attempted to strike her with a full-size mirror, but she missed. The glass shattered everywhere. Officers were able to observe the shattered glass. The defendant then grabbed a laptop and began striking the defendant on top of her head and arm. The grandmother, who was also present, was awakened by the commotion and went upstairs and witnessed the defendant attacking her daughter. She intervened to stop the attack and ended up calling 911. However, when she went to call 911, the defendant was heard stating that if you call the police, I would tell them that you and grandma jumped me. While the defendant doesn't have any criminal history, this was a violent attack. You have glass shattering, which that is likely to cause serious injury. And the state is concerned. The victim has spoken to our office and she would request a no contact order and a stay away from the home located at 400 Griffin Street. My understanding that she is waiting on a dorm, so she may be leaving soon to go to college. So the state's recommendation is a $4,500 surety bond. That's $2,000 on the simple assault, $2,500 on the simple battery, no further contact, stay away from the address, no alcohol, drugs, or weapon, and 1 day anger awareness. And we would ask the court to sign for Ms. Kiara Harris if she is on the Zoom call.
I see that she's here and I will give her the opportunity to speak if she chooses to in just a moment. This your case, Ms. Cook?
It is, Your Honor.
Okay, you can proceed.
Thank you, Your Honor. Ms. Davis is 37 years old. She does have 2 children, including the complaining witness. Her other child is a 12-year-old son. She's a high school graduate, currently employed part-time at Kroger. As far as it relates to, without getting too much into the factual history, she does dispute the allegations against her, and we do maintain that she is innocent of nothing until proven guilty. There is another witness who was not mentioned by the state, that being Ms. Davis' best friend, who was present in Ms. Davis' room where the incident originally began. And if I can give the court a little more background information, Ms. Davis, the complaining witness, who was the daughter of Lakeisha Davis, she's actually not supposed to be residing at this incident, where the incident occurred. She signed an agreement, I believe, back in November of 2022, because this is under the housing authority. So she's not supposed to, and was not supposed to be there.
Supposed to be there, Ms. Cook?
The complaining witness, the alleged victim in the case, she's not supposed to be there.
And that's Kiara Harris, right? Kiara Harris?
Kiara, is it Davis or is it Harris? I'm sorry.
That's what was confusing me. I think from Mr. Young, I got down Miss Kiara Harris, who I see on the line here.
You're correct, Your Honor. It's Kiara Harris, not Davis. I wrote Davis.
Okay. Okay.
Yes.
I just wanted to make sure. And you're telling me that Miss Harris is not supposed to be at that residence?
Based on an agreement between the housing authority, yes, she was told not to be there as of November of 2022.
Okay, and whose residence is it? Is it Miss Davis's residence?
It's Miss Davis' residence, and only her and her 12-year-old son are on the lease. Okay. Mom does come over routinely to visit the grandchild. But again, there was another person who has not been mentioned, Miss Davis' best friend, who was also present. So what I'm saying is that there's clearly a factual dispute here, and Miss Davis should be given the benefit of her innocence at this particular point. She does not have any criminal history, and she does have a part-time job that I believe is still being held for her, as well as she's the primary caretaker to that 12-year-old son. So for that reason, Your Honor, we will be asking for a signature bond. She does not really have the financial means to be able to post any other bond. My understanding is she does not have any issues with the no contact provision for her daughter at this time.
Okay, thank you. Ms. Harris, I see you there. This is your opportunity to address the court if you choose to. You do not have to address the court, but if you choose to, you'll have to unmute yourself and I'll need to swear you in. Can you raise your right hand for the court?
Hi.
Hi, good afternoon, ma'am. Can you raise your right hand? Thank you. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth? Did you hear my question? Oh, okay, you can put your hand down. What would you like to tell the court?
The agreement that she's talking about with the housing authority, my mom said I could stay here until I got the dorm, and I told her that she needs to leave, and that's what she said that she was gonna let me do. And with the housing authority, I had issues with my classes. That's why she went to the agreement, because of the distance with her boyfriend, because I was trying to her at the time. And now since this has occurred, now she might say, oh, no, you have to get out now. So, yeah.
Okay, and it's my understanding that you don't want any further contact with your mother. Is that correct?
Yes.
Okay, so if that's her residence, you understand that if you're not to have any contact, you're going to have to find someplace to go.
I understand that.
Okay, all right. Anything further?
No, that's it.
From the state.
Okay. Your client has her hand up, Ms. Cook.
Your Honor, I would advise her at this particular time to maintain her right to remain silent.
All right. So given what I've been told, this is Miss Davis's residence. Miss Harris is not supposed to be at that residence. I'm going to issue a no further contact between Miss Harris and Miss Davis. As such, Miss Harris, you're going to have to vacate that, and that's your wishes also. But Miss Davis, you cannot go back there until she has vacated, because I don't want you all don't have any contact. So you'll be able to go back to that residence with law enforcement to make sure that Miss Harris is not at that residence. If Miss Harris is still there, then you necessarily won't be able to be there until she is not there any longer. So it's going to be a $2,000 signature bond on each charge, which is a $4,000 signature bond through the jail. No further contact with Ms. Harris. You can go back to the location as long as Ms. Harris is not at the location with a one-time escort from law enforcement to make sure that she's not there, and no drugs, alcohol, or weapons while out on bond. Okay. Again, your client has her hand up, Ms. Cook.
May I ask a question?
Yes.
Okay.
I mean, not you. I'm sorry. I thought that you have a right to remain silent, Ms. Davis. Anything you say can be used against you. I've given you a signature bond in the case. If you have any questions regarding that bond, you can speak with Ms. Cook. But I don't want you to say anything that might get me to change my mind. Do you understand what I'm saying?
Yes, sir. I just want to know, like, since I have a 12-year-old son, what time frame do I have to be away from the house? Because I have to take care of him as well.
Okay. Well, it's my understanding that, given that it's your place of residence, Ms. Harris does not wish to be there. I don't have the authority to evict her, but once but if she's there, she says she doesn't want to be there. She doesn't want to have any contact with you. So I'd imagine that she needs to go ahead and if she's going to not reside there, she needs to go ahead and find herself someplace else to reside. But I can't make her leave. You would have to have an eviction for that. So what I'm allowing you to do is to go back to that residence when she's no longer there. Okay?
Yes.
And I would encourage Ms. Harris has to take care of a child, that you need to go ahead and find yourself a place to live. Okay? So good luck to you, Ms. Davis.
Your Honor, what was that bond amount? I'm sorry.
You're fine. It's a $4,000 signature bond through the jail, $2,000 on each count.
Thank you.
Okay. Okay, who do we have next?
Next, we're gonna go to Mr. Brandon Miller, and he's position 13.
Yes, good afternoon, Mr. Miller. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we are conducting by video. Do you agree to have your case heard by video?
Yes, sir.
All right, Mr. Miller, you've been charged in case 23 CR 001396F with a hit and run, following too closely and no insurance. Is there a history, Mr. Howard?
Yeah, first arrest.
Okay, Ms. Duncan?
Yes, and this incident did occur on September 4th, 2022. The victim in this case is Andrew Chandler. That's Andrew Common spelling Chandler, Chandler. On this incident at about 1800 hours, officers indicated in the area near Piedmont and Lakeshore Drive, the defendant's vehicle struck the victim's vehicle from behind. It's indicated that both parties then pulled off the road into a nearby driveway near where their collision had occurred. The defendant then got out of his vehicle, checked for damage to his vehicle, and without making any attempt to talk to the victim or provide any information, got into his vehicle and drove away. Officers were able to identify the defendant because he responded to an SOS at the precinct and was a part of a lineup, and he was subsequently identified by the victim in this case. Although this defendant does not have any prior criminal history, he has at least 4 citations in his criminal history going back between the years of 2017 and 2021, earliest being 2013 for speeding and expired or no license. It's also indicated that once officers were able to find out who the owner of the vehicle was from that lineup identification, it was revealed that the defendant was in fact the registered owner of the vehicle of the same type that had hit the victim's car, and that vehicle did not have valid insurance coverage. So it's for those reasons, Your Honor, the state is going to be requesting a total $2,500 surety. That's $1,500 on the hit and run, $500 on the following 2 closely, and $500 on the no insurance. No further contact with the victim, Andrew Chandler, no alcohol, drugs, and weapons, and no further violations of Georgia law, as well as a defensive driving course, and no driving unless validly licensed, insured, and registered. I don't believe we were able to make contact with Mr. Chandler, but the state would like for the court to sound for him just in case he is here.
Okay. Mr. Chandler, this is your opportunity to address the court. Doesn't appear so, Ms. Duncan. Good afternoon, Ms. McLeod.
Good afternoon, Your Honor. My client is 26 years old. As the state has stated, he has no criminal history. My client is a student. He has a bachelor's degree and tells me that he's currently working on his master's degree. So he really is not employed, Your Honor, and has no money to pay bond. Mr. Miller tells me that he actually was not the person driving the car, that his car had been loaned to someone. So he denies that he was the person who actually engaged in this hit and run and said he was not at the location at the time, Your Honor. The court will note that he has no criminal history. And I would ask the court to give the client a signature bond. He can get out of jail and get back to his classes and to his life, Your Honor. And this incident apparently happened, I believe, from the warrant sometime last year, if I'm not mistaken, Your Honor. There is no reason why my client would have contact with the alleged victim, so we do not have a problem with that provision. Nothing.
Okay. So, is there something further, Ms. Duncan?
I was going to say the victim did in fact identify the defendant on scene because they saw who he was and was able to get the tag number of the vehicle that hit their car, and later identified them in a lineup. Nothing further.
Your Honor, my client.
It's going to be a signature bond, Ms. McLeod. Okay.
Thank you.
Okay.
Thank you.
A $1,500 signature bond through the jail for the hit and run, and $500 through the jail for each of the other charges, making for a total of a $2,500 signature bond through the jail. And no further contact with Mr. Chandler, no drugs, alcohol, or weapons while out on bond. Good luck, Mr. Miller.
Thank you, Your Honor.
You're welcome.
Your Honor.
Yes.
I usually don't do this, but for position number 8, Vanessa Hunt, the victim is actually here in the courtroom. She was in the waiting section. Do you guys want to speak to her? She would like to talk to you regarding Ms. Vanessa Hunt.
Who is Ms. Hunt's attorney?
Honor, it was me.
Okay, and
I believe it
All
is
right.
important for no further contact issue, Your Honor. They
Okay,
will-
all right, so you can bring her on up.
Okay. Go sit over there. You go sit down. Right next to it, yep.
Yes, good afternoon. Tell me your name, Ms. Hines.
Shakindria Hines,
Okay, and can you spell your first name for me?
SHAKENDRIA.
And what would you like, raise your right hand for me, Ms. Hines? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes,
Okay, you can put your hand down. What would you like to tell the court?
I wanted to say that I wanted to drop all the charges.
Okay, well, it's up to the state whether they're going to drop any charges. Anything else what would you like to tell the court in regards to the incident or in regards to Ms. Hunt?
Everything that we resolved, everything. And
Okay, so this alleged incident happened in November of last year. Have you all been around each other since that time?
yes,
Have you had any problems before or after this incident?
no,
And are you afraid of her?
no,
Okay. Anything further, ma'am?
no, that's it.
Okay, any questions, Mr. Agba?
Yes, Your Honor. Ms. Hines,
Yes,
back on November 9th, when you called the police, were you the one who called the police about this incident?
I did.
And did you tell the police that Ms. Hunt punched you in the face?
No, I didn't. They didn't see my lip, but it was out of anger. And so once they called the police, there's no like relationship problems.
Yes, ma'am. But did you tell the police that you were punched in the face?
Yes,
And were you punched in the face
yes, I was.
by Ms. Hunt?
Mm-hmm.
Thank you. Nothing further, Your Honor.
Okay, given that Ms. Hines is here, the rest of my order stands. Given that Ms. Hines wants contact, and given that this happened back in November of last year, I'm going to change the no further contact to a no further violent contact. And there's no stay away, and the stay away will be lifted. All right. Thank you, Ms. Hines.
Thank you.
The SAP reset date is March 23rd.
Correct.
Next, Your Honor, we're gonna go to position number 10, Mr. Jeffrey James. Position number.
Okay. Good afternoon, Mr. James. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 23 CR 001393A with simple battery. So history, Mr. Howard?
Yes. Got a total of 9 cycles. Well, this is 10th arrest. Last arrest was last month in Clayton County. Simple battery, family violence. Theft by deception, NOLO, 2014. Hold on. 2018, he had an arrest as well. Trespass, simple battery, 2 counts, FTA for reckless conduct. Before the theft by deception was 2013 probation. Underlying charge was burglary, theft by taking, and obstruction. 2012 probation, same thing. That's it.
Good afternoon, Ms. Falk.
Good afternoon, Your Honor. How are you?
I'm doing well, thank you.
So this incident happened on February 13th, 2020 at 1919 Metropolitan Parkway, Atlanta. That's the Lacura Bar and Bistro. Mr. Jarvis Shannon and his cousin Shandaria Carricker had been in a year-long disagreement. And Jarvis's first name is Jarbais. Last name Shannon, Shannon. Mr. Shannon stated that he was told by his family that Miss Carricker was looking for him. And while he was at Lakura, his cousin, Miss Carricker, approached him along with 5 other people, including her boyfriend, who is the defendant. While exchanging words with Miss Carricker, the defendant reached around from behind Miss Carricker and punched Mr. Shannon in the face. So that is how this incident occurred. We did have an opportunity to speak with Mr. Shannon. He informed us that that the defendant, was dating his cousin at the time of the incident, and they had some issues, and that apparently the defendant felt the need to protect her and then went to the club where the victim was then jumped. He stated he did not sustain any injuries. However, he would like a no contact order because although he is over this part of his life, he doesn't want the defendant to come out of jail and retaliate against him. The state is recommending we would like to go ahead and recommend a $3,500 signature bond through pretrial services. We are also recommending 1-day anger awareness, stay away from no further contact with Mr. Jarvis Shannon. And we are further asking that the defendant stay away from the 1919 Metropolitan Parkway Avenue, which is the Lakura Bar and Bistro. We would sound for Mr. Shannon. He did not say he would be present, but we just want to make sure. So we would like to sound for Mr. Shannon, and that is all for the state.
Okay, Mr. Shannon, if you're present, now is your opportunity to address the court. It doesn't appear so. Ms. Kim, is this your case?
It looks like Ms. Kim stated this is the conflict public defender's case, but given the state's bond recommendation, I don't see, I think if it's possible, if the defense wishes to go pro se. Oh, Ms. McLeod is here. Okay, never mind.
I am here, but I believe Ms. Kim had spoken with him, not me.
Okay, Ms. Kim.
I'm sorry, I didn't speak with him, Your Honor.
Honestly, Your Honor, I just need somebody to say, yes, they agree to a signature pretrial bond. So if it's the defendant, that's fine.
I'm happy to do so.
Okay, do you want to take this case on, Ms. McLeod?
Yes, Your Honor.
Okay, and
Thank you.
I know that you haven't had an opportunity to speak with him, but he's getting a signature bond through pretrial per the judge, 1-day anger awareness, stay away from that bar, and no further contact with Mr. Shannon. I mean, I think that would be something that that he would want to agree to.
How much was that bond?
It's a $3,500 signature bond through pretrial per the judge.
Okay, thank you.
He's position number 10.
Thank you, Your Honor.
Ms. McLeod, he said he did speak to you.
He did?
Yeah.
Who is this?
Position 10, Mr. Jeffrey James.
Just a moment. Yes, he did. He did.
Okay,
I
so,
I don't understand who he is. Yes.
Okay. Mr. James, you're going to get a signature bond through in this matter, but you're going to have to make sure that you show up for your next court hearing. So if you don't, then they're going to put a warrant out for you. Okay.
All right.
All right. Good luck to you, Mr. James.
And that was a $2,000 signature bond, Your Honor?
It's a $3,500 signature bond.
Through pretrial or through jail?
Yes, through pretrial.
All right, thank you.
You're welcome.
Next, we have position number 4, Mr. Dwayne Douglas II.
Good afternoon, Mr. Douglas. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Good afternoon. Yes, sir.
Yes, good afternoon. Mr. Douglas, you've been charged in case 23 CR 001395C with battery family violence. Is there a history, Mr. Howard?
This is 9th arrest. 2021 burglary reduced to trespass. That was dismissed. He has history out of state. I think it's Kentucky. Open case for speeding, possession of marijuana, operating a motor vehicle, unlawful with alcohol, criminal mischief, second degree, assault, fourth degree, DV, contempt of court, assault, fourth degree, DV. It says minor injury and strangulation, first degree, and another assault, fourth degree. That's it.
Yes, Mr. Agbe.
Yes, Your Honor. This incident took place on March 8th, 2023 at 3717 College Street. Officers responded to Code Enforcement Officer Ellis calling about two males who were engaged in a fight outside of the College Park police station. When officers arrived, they observed personally the defendant shoving the other male who has been identified as Mr. Dwayne Douglas Sr., the father of the defendant. Defendant was identified as a primary aggressor. Officers that responded to the scene spoke with Code Enforcement, who stated that they personally observed the younger Douglas striking the older Douglas, and they did observe a visible scratch to the neck of Douglas Sr. Your Honor, like pretrial has stated, there are about 7 cycles with some concerning allegations or accusations. Because they're out of state, Your Honor, we do not have the deposition, how those cases were disposed of. There is also one open case here in Georgia. There's the fear of, because of the relationship between the two, there is that fear of intimidation. There's also a flight risk, because it appears that the younger Douglas is a resident of Kentucky based on some of the things on his criminal history. Your Honor, we have attempted to reach out to Dwayne Douglas Sr. Those attempts as of yet have been unsuccessful. I don't know if Mr. Douglas Sr. is present in the court. We would ask to sound for him if he is available. But in light of all the facts known, Your Honor, we would be asking for a $2,500 surety bond, no contact with the victim. Based on the police report, it doesn't appear that they reside at the same address, but also stay away from the older Douglas's address. No alcohol or drugs or weapons while under supervision.
Okay, Ms. Cook.
Thank you, Your Honor. Mr. Douglas is 23 years old. He actually has lived in Georgia all of his life, with the exception of a brief period last year when he did go to Kentucky to stay with a friend. So he does, his ties is in Georgia, has been in Georgia. He's definitely not at risk of fleeing the state. He's no longer associated with that particular friend. He has completed high school. Right now, Your Honor, he's not currently employed. It's my understanding that there may be some underlying issues as it relates to him being on, or supposed to being on, medication that did not affect his ability to be able to communicate with me in any way. And I don't know the extent. We didn't get to the details or deep into the details. My understanding is that he would reside with his mother. I did also try to attempt to reach his father. I was also unsuccessful in doing so. Based on his limited financial means, I do understand that he does have prior criminal arrest. We are still asking the court, because he is still innocent until proven guilty. I don't believe that he has any felony convictions at all. He does have pending cases. It looks like he has appeared for those previous cases. So we are asking the court, and again, he has been in Georgia from Georgia and just was in Kentucky for a brief stint. We are asking the court for a signature bond. No drugs or alcohol or weapons is not an issue as long as he's able to take his medication as prescribed by a doctor.
Okay. Let's see. I don't see Mr. Dwayne Douglas Sr. on the line, but if you are on the line, Mr. Dwayne Douglas Sr., now's your opportunity to speak. If not, it's going to be $1,000 good bond, no further contact with Dwayne Douglas Sr. and stay away from his residence, and no drugs, alcohol, or weapons while out on bond.
Excuse me, Your Honor.
Miss, hold
I
on,
would
Mr.
advise you to, you know, your right to remain silent. Anything you say, you know, can be used against you. So I would advise you to exercise that at this time.
Yes, ma'am. Thank you. But however, Your Honor, I do me and my dad,
Mr. Douglas, can
we
you?
love each other.
Mr.
But
Douglas.
we're just kind of going through a stint right now. But I do I do need him as a like support. So could it be like non-violent interaction? And
So-
I still do talk to him and we text and all that.
Okay, so let me just say, Mr. Douglas, right now, we have not heard from your father. So if your father, and this bond can be modified in the future. So we haven't had a chance to speak with him. We don't know his desires. And he's not here with us today. So once we get in touch with him, if he says that he wants contact with you, then we'll reconsider that part of the bond. But for right now, I understand you have someplace else that you can go. So for right now, do not contact him because I don't want you being in violation of this order, okay?
Yes, sir.
All right, so if your dad wants us to change it, then we will consider that in the future. So, all right, good luck to you, Mr. Douglas.
Thank you.
You're welcome.
Next, we have position number 5, Mr. James Graves. Position number 5.
Good afternoon, Mr. Graves. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Graves, you've been charged in case 23 CR 001391G with improper erratic lane change, driving under the influence of alcohol less safe, and driving under the influence of alcohol, a concentration of 0.08 grams or more. Is there a history, Mr. Howard?
First arrest.
Okay. Mr. Young?
Your Honor, we do show more history with Mr. Graves. He had a prior DUI in 1990, another in 1991, a DUI where he pled NOLO in 1996, and a DUI from 2010. I believe his most recent DUI conviction was in 2012, and I'm showing the 96 convictions were also, the 96 DUIs were also convictions. This incident occurred on March 9th, 2023 on the Georgia State Highway 140, where Roswell PD observed the vehicle making proper lane changes. The driver allowed his tires to cross over the dotted lines, and the driver's side also crossed over the double yellow lines. The defendant traveled at a much slower pace than other vehicles. Law enforcement made contact with the driver. The defendant, James Graves, noticed that his eyes were red and watery. His speech was slurred, and there was an odor of alcohol coming from his breath. The defendant admitted to officers that he had consumed alcohol. Defendant's performance on the standardized field sobriety test indicated signs of impairment, and the defendant's BAC, according to the officer, was 0.163, double the legal limit. So the state's recommendation, based on the fact that the defendant has consistently been arrested and convicted for DUI, and he posed a danger to the community while driving on the highway impaired, the state's recommendation is a total of a $7,500 surety bond. That would be $3,500 surety on each DUI and $500 for the lane. No alcohol, drugs, or weapons. No driving unless to work, court, or medical, and alcohol, drug evaluation and treatments. There's nothing further from the state.
Ms. Cook?
Yes, Your Honor, I don't, Mr. Graves, based on my conversation with him, is 75 years old, lived in Georgia for the last 37 years of his life, I believe, has a bachelor's degree from Alabama. He's retired from Cargill, where he was involved in a livestock feed pet food industry. He's been married for the last 56 years. My conversation with him is that this is his first arrest, no priors. So I'm not certain where the state is getting that from. However, I could be wrong. Oh, I just got a message. The history is not him. So I do believe that the state is mistaken about his prior criminal history. And I just want to make the court, aware of that we're adamant that that's not him unless. So I don't want you to consider that. I mean, I understand that that's what they're telling you, but based on the pre-trial report and my conversation with the client, this is his first encounter with the law. And with that, he's 75 years old. I know he waited until now to get in trouble. We would be asking the court, as he is on a fixed income, he's retired. We will be asking the court for a signature upon. He does qualify according, or he's recommended for pre-trial for unsecured judicial release. He did submit, I believe, to the testing, so his license would not be suspended. So no drugs or alcohol wouldn't. He has no issues with that. But as far as limiting his driving only, he did comply with the state administered test. So we would ask the court not to limit his driving to just the places that the state mentioned. But again, the condition of no drugs and alcohol, we believe is reasonable. And nothing else from the defense, Your Honor.
Okay, for the red lane change, a $500 good bond. For each of the DUIs, a $1,000 good bond, making it a total of a $2,500 good bond. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Graves. Your client has his hand up, Ms. Cook.
I don't, like the history.
We've addressed that. I do believe the court did take that in consideration. And if you have any questions about your bond, I can give you a call.
Okay.
Right.
Good luck to you, sir.
Thank you.
You're welcome.
Next, we have position number 6, Mr. John Harrison. Position number 6.
Good afternoon, Mr. Harrison. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Here we are.
Thank you. Mr. Harrison, you've been charged in case 23 CR 001392A with improper erratic lane change, driving while your license is suspended or revoked, a willful obstruction of a law enforcement officer, 2 counts, and giving false information to law enforcement. Is there a history, Mr. Howard?
17 total. Last arrest was 2020, probation. Driving without a valid license, obstruction. Giving false name from 2020 out of the cab. 2017, failure to appear conviction. 2016, theft by taking 2 counts, conviction out of DeKalb County. 2016, suspended license, no-load. 2013, probation. 2013, giving false name, conviction. 2012, driving without a valid license. 2011, suspended license. 2011, suspended license, no-load. And 09, probation.
Okay, Ms. Duncan.
Yes, Your Honor, this incident did occur on February 8th, 2023 in the area of Medlock Bridge Road. Officers conducted a traffic stop after they noticed the defendant crossing 3 lanes of traffic without stopping in between. The officer who stopped the defendant had to apply his brakes suddenly to avoid colliding with the defendant, crossing over the solid lines and going straight in a turning lane. When officers approached that vehicle, they asked the driver of the vehicle, who was identified as the defendant, for his driver's license. He indicated that he had done nothing wrong and that he was not going to provide the driver's license to the original officer, that was Officer Elliott. Officer Elliott further explained that it was a lawful command given that he was doing a traffic stop. He continued to refuse. Officer Elliott called for backup, and then Officer Roop came and asked the defendant for his identification. He initially told Officer Roop that he was not going to give him his identification. However, he eventually complied with Officer Roop's request for information, and they asked him to get out of the vehicle. they attempted to locate his driver license and it could not be found. He refused to get out of the car. Once officers were able to get him out of the vehicle and place him in handcuffs, they asked him for more identifying information. He did in fact give a wrong date of birth of October 7th, 1970. And that is in fact his incorrect birthday. He was finally identified, and based on his GCIC, it showed that his license had been suspended out of South Carolina. And then he further admitted that he knew that his driving license was suspended. And he said that it was according to unpaid parking tickets. However, given this defendant's history with several convictions and arrests for driving while license suspended and giving false information, the state has concern about his risk of reoffending, given that he continues to drive on suspended license and give officers false information when arrested or asked about identification in an attempt to mislead those officers. We do have concern about this defendant's flight risk, given that he does have an FTA guilty conviction, as well as this defendant's likelihood to positively respond to the legal process. He has 16 cycles from what I've seen. Some of those include driving with suspended license and giving false information, as well as probation violations. It is for those reasons the state is going to be requesting a total of a $3,250 surety. That's $500 on the driving or erratic lane change. That's $1,000 on the driving while license suspended. That's $500 on both of the obstructions and $750 on the giving false information to a law enforcement officer. We're going to ask for no further hindering or disruptive contact with either officer involved in this incident, no alcohol, drugs, and weapons, no further violations of Georgia law, and no driving unless validly licensed, insured, and permitted by DDS. Nothing further.
Ms. King?
Yes, Your Honor. Mr. Harrison is 51 years old, and his birthday is October 7, 1971. People make mistakes. I don't think he was intentionally giving false information. Sometimes it just happens. One letter difference. One number. But anyway, he has been here in Georgia for about 2 years, ever since his mother passed away 2 years ago. He resided here. He has a fiance here in Georgia, and he has he's gainfully employed at Studio 1795. He does maintenance, and he successfully graduated from high school, and he's also proud father of 14 years old minor and some adult kids. We would like to request for signature on bond for his driving cases and traffic violation, and that's our wishes. Signature on bond. Thank you.
This is $100 good bond. For each of the other charges, it's going to be a $250 good bond. That makes for a total of a $1,500.
You're breaking up. I can't
Yeah,
hear you.
can't hear you.
We didn't hear the bond amount.
All right, can you hear me now?
That's better.
All right, so again, for the driving while license is suspended, a $500 good bond. For all the other charges, a $250 good bond. That makes for a total of a $1,500 good bond. No drugs, alcohol, or weapons while out on bond. And obviously no driving without a valid license. Good luck to you, Mr. Harrison.
Thank you, Your Honor.
Thank you, Judge.
Next, Your Honor, we have position number 11, Mr. Kenzie Belgidi.
Good afternoon. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. You've been charged in case 23 CR 001394G with theft of service and public drunk. Is there a history, Mr. Howard?
I got second arrest. Last was 2005. Unregistered motor vehicle, suspended license. Out of, I think, Massachusetts. Yeah, Massachusetts. He's a resident of Cambridge, Massachusetts.
Okay. Ms. Falk?
Yes, Your Honor. This incident happened March 8th, 2023 at Cheetah Lounge at 887 Spring Street, Northwest Atlanta. The defendant was picked up by Tomas Ridley Jr., who is a limo driver from the Cheetah Lounge. Mr. Ridley then drove the defendant to Reverb at Hard Rock, but the defendant declined to pay for those services. The defendant was given the option by police. It appears that Mr. Ridley drove back to Cheetah Lounge to address this with police. The defendant was given the option to pay $40 for the limo ride, but he refused. The officer went so far as to tell the defendant he'd go to jail if he didn't pay, but he declined and chose to go to jail instead. We have had an opportunity to speak with Mr. Ridley. Mr. Ridley stated that the defendant was drunk when it was time to pay, that he asked how much his services would be, and he told the defendant it would be $180. He then stated the defendant then said the victim then told the defendant that he had to pay him because oftentimes people run without paying. When the defendant refused to pay for the services that he had been provided, Mr. Ridley said he was going to call the police, and the defendant told him to go ahead. At that point, the defendant got into the officer's face at one point and yelled he wasn't going to pay, at which point he was arrested. Apparently, the argument grew so loud that that is why the defendant was charged with public drunk, is because the argument got out of hand to the point where it could be heard through the parking lot. The state's recommendation is a $3,000 signature bond through pretrial services, stay away from the Cheetah Lounge, no alcohol, drugs, or weapons, and no further contact with Mr. Thomas Ridley Jr. I don't know if he is here on the Zoom, but we would like to sound for him.
Mr. Ridley Jr. on the line? Doesn't appear so. Since he's out of state, it's going to be a $3,000 signature bond through the jail, and no further contact, and stay away from the Cheetah Lounge. Is that fine with you, Ms. Kim?
Yes, Your Honor.
And the state would ask for the breakdown to be $2,000, $1,000.
Okay, $2,000 for the theft and $1,000 for the public drunk. All right, good luck to you, sir.
Next, we have position number 15, Mr. Michael Shannon. He's taking a plea.
Okay.
And I do have the paperwork.
And good afternoon, Mr. Shannon.
How you doing?
I'm doing fine, thank you, sir. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Oh, yes, Your Honor.
Okay, you can put your hand down, Mr. Shannon. Let me just tell you first, you have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. It's my understanding that we have provided you with a public defender, but you wish to enter into a plea on this criminal trespass charge?
Yes, I do, Your Honor.
Okay, and just so that I know that you, before I take the plea, that you understand what the state is asking for, what is the recommendation of the state, Ms. Duncan?
Your Honor, the state's recommendation in this case is 12 months probation, credit for time served, with the balance suspended, and a stay away from the BP gas station located at 3040 Lakewood Avenue in East Point, and no alcohol, drugs, or weapons.
So he's getting credit for it's 12 days to serve 12 months to serve 2 days, credit for time served 2 days. Is that right?
Yes, I believe that's what it says on Odyssey, 2 days.
Okay. What's your question, Mr. Shannon?
While I was arrested, I've been arrested since February the 7th, right, Your Honor? And
I have the offense date down as February 7th. So
yes.
you've been in.
Yes,
you've been.
It ain't nothing about this case, right? It's all about once I got over here, it's telling me that I got a hold for Plain County when I never been to Plain County, or I never been arrested in Plain County. So I was wondering, how is that possible? And
I can't answer that, Mr. Shannon, because, you know, I don't know anything about Clayton County, any charges that you might have. The only thing that I'm able to help you with today is this criminal trespass, and the state is offering you a time served plea to the criminal trespass charge if you want to accept that, okay? But you're going to have to go to Clayton County to deal with any issues that you have there because this court doesn't know anything about that, okay?
Oh, yeah.
Say it again.
I said, yes, sir. Yes, sir.
Okay, so given what the state said, do you still wish to enter into this plea?
Yes, sir.
Okay. Ms. Duncan,
Yes.
go ahead.
Yes, I was going to say, would the court like a recitation of the facts as for the state's recommendation?
You've already given me the recommendation, so if you can just go through the facts for me.
Okay, on February 7th, the defendant was told to stay away from that location. He was given a criminal trespass warning. He returned to that location later that day, and he was taken into custody. That's the reason for the state's recommendation in this case. We'd ask that the defendant stipulate to the factual basis venue and ID.
I don't think that he understands what that means, Ms. Duncan. You've already given me the recitation, so we'll move forward with that. Mr. Shannon, it's my understanding that in case 23 CR 001399F, you wish to plead guilty to criminal trespass. Is that correct?
Oh, yes, Your Honor.
Are you under the influence of any drugs or alcohol this afternoon?
No, Your Honor.
You've been given the opportunity to be represented by counsel. It's my understanding that you wish to proceed without the assistance of counsel. Is that right?
Yes, Your Honor.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you've given up your right to a trial by jury?
Yes, I am. I'm well aware, Your Honor.
Has anybody forced you to plead guilty?
No, sir.
Okay, I'll accept your plea as negotiated, Mr. Shannon. Good luck to you, sir. You know you can't go back to that BP.
Oh, yes, sir.
Okay, all right.
Position 2, Mr. Camps.
Good afternoon.
Miss Camps. Want to say Miss Camps?
Okay, and do you prefer to go by Ms. Camps?
Miss Camps, yes.
Okay, good afternoon. Good afternoon, Ms. Camps. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yeah, it's my first time ever having a case with y'all, period.
Okay, so all I'm asking right now is that you, it's all right to do this by video. Is that right?
Yes.
Okay, you've been charged in case 23 CR 001390Y with loitering and prowling. Is there a history, Mr. Howard?
Yeah, 8 total. 2018 misdemeanor possession of marijuana, possession of drug-related objects, FTA, solicitation, obstruction. 2016 resisting an officer. That was a conviction.
That's not in Atlanta, though. That's in other cities.
Okay, Ms. Camps, please remain silent. You have the right to remain silent. Anything you say can be used against you. Let your counsel speak on your behalf, okay? I don't want you saying anything that's going to get you into any trouble. Is that it, Mr. Howard?
Those were 2018 different arrests. It wasn't all one.
Oh, okay.
One arrest, just so you know. Okay.
Is that it?
Yes.
Okay. Mr. Young?
Yes, Judge. This case happened on March 8th, 2023 at 2470 Cheshire Bridge Road. That is the Helos Apartments. On this day, law enforcement responded to that address in reference to a prowler report. Officers made contact with the security officer who advised that he witnessed the defendant inside one of the vacant units, 2026, I believe, in the bathroom taking a shower without the consent of the property manager and the leasing agent. The state is concerned about a possible flight risk as the defendant showing on the criminal history I received that to have a wanted in Richmond, Georgia, on an FTA for possession of drugs and misdemeanor marijuana. The state's recommendation is a $2,000 surety bond, stay away from the incident location, and no alcohol, drugs, or weapons. That's all from the state.
I'm sorry, tell me your bond recommendation again, Mr. Young.
A $2,000 surety bond, stay away from the incident location,
Okay.
and no alcohol, drugs, or weapons.
Okay, Ms. Cook, I'm gonna give Ms. Camps a signature bond, $1,000 signature bond through the jail. Stay away from Cheshire Bridge Road, those apartments, and no drugs, alcohol, weapons. Does that suit you?
Yes, Your Honor, thank you.
Okay, so Ms. Camps, you can't go back to that Cheshire Bridge Apartments, okay?
Okay, that's fine.
All right, and I'm gonna let you out, but you're gonna have to come back for your next court hearing, otherwise I'm gonna put a warrant out for you, okay?
What day is that, so I know?
You'll get notice of when that's gonna be.
Okay, thank you.
Oh, you're welcome. Who do we have next?
Your Honor, the last two positions, they were requests for breakout rooms, position 7 and position 17.
Okay, so who needs to be in the breakout rooms?
I do.
Okay, so
I do as well, Your Honor. I represent position 7.
okay,
Your Honor,
I
just to
do
be
it.
sure, at position 17, I know we did not, sorry, excuse me. Are we going to address position, excuse me, Your Honor, trying to find it on the calendar.
It's 16. Are you talking about my case?
Yes.
Position 16. And what about position 14?
those are both waivers,
Okay.
my understanding.
What about Mr. Cargill?
Mr. Cargill was NOD.
Okay.
Okay, so it appears that
Supposed to be in, I apologize, Judge. Who's supposed to be in which breakout room?
okay, so I know Ms. Kim is going in, Ms. McLeod are you going in, Ms. McLeod?
Yes, Your Honor, I
Okay.
represent Mr. Williams.
Ms. Cook represents position number 7, Mr. Hightower.
Okay, Ms. Falk, Mr. Agbe.
Yes, Your Honor.
Anyone else? Did I get everybody?
Is everybody going in the same breakout room or is this more than one breakout room?
Yeah, no, we're all gonna go to the same breakout room.
Oh, okay, I was confused. All right, thank you. So Mr. Agbe, Ms. Falk, you, Judge Morrow, Ms. Cook, and Ms. Kim.
And Ms. McLeod.
And Ms. McLeod. Okay, thank you. Ms. Cook, were you supposed to be a part of the room as well?
I was.
Okay, I'll take it.
Hello, what's going on?
You can mute your mic. They'll be back shortly.
Can you hear me?
Okay, do we have the jail? Oh, there we go. So who do you have next for me?
Honor, we could bring up position number 17, Mr. Tyson Williams.
Good afternoon, Mr. Williams. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. We're handling this by video today. Do you agree to have your case handled by video?
Yes.
Thank you. Mr. Williams, I've had an opportunity to discuss your case with both your counsel and with your father. My bond order is going to be a $2,000 good bond, that you have no further violent contact with your father. We're going to get you a mental health evaluation, and you're to have no drugs, alcohol, or weapons, but you are to stay on any medication that has been prescribed for you. Okay, so that will be the order of the court. Good luck to you, Mr. Williams.
You say it again?
Yes, it's going to be a $2,000 good bond. We're going to require that you have a mental health evaluation and that you have no further violent contact with your father.
A mental health evaluation where?
Okay, well, your attorney's going to be able to explain all that to you, okay? So she'll be in touch with you, and she will let you know what the process is from here, okay?
And call, Mr. Williams.
You said what?
You can give me a call.
All right. And there's no way I can make it a signature bond?
Not at this time, Mr. Williams. I've had a discussion about that. You won't be getting a signature bond today, okay? All right, Norris, who do we have next?
Next, we have position number 7, Mr. Curran Hightower.
Good afternoon, Mr. Hightower. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. We're conducted by video. Do you agree to have your case heard by video?
Yes.
Okay. Happy birthday to you, Mr. Hightower.
Okay.
We discussed your case also. You're going to get a signature bond today, a $2,000 signature bond through the jail, and you're not to go back to MARTA. I'm going to let you out, but you're going to have to make sure to show back up for your next hearing. Otherwise, they're going to put a warrant out for you, okay?
All right.
All right. You have a good rest of your day.
Okay. That's all we have in courtroom 2, Your Honor.
Okay. We have 2 waivers that we're going to have to discuss, so I appreciate it. I'll see you all next time.
Okay. Thank you, Your
Okay.
Honor.
So let's go to position number, 14 first. Veronica Riles. Does Ms. Riles have a history? Is Mr. Howard on with us?
Yeah, I'm here.
Okay.
She got 12 previous cycles. Last arrest was last month for shoplifting, giving false name out of the cab. That's open. Got to open terrorist threats, criminal damage to property out of the cab as well. Open PR charge, simple battery against police. Yeah, that's all the DeKalb County. Got an August 2022 disorderly conduct arrest on MARTA. April 2022 simple battery. 2020 probation simple battery DV. 2019 probation violation simple assault simple battery family violence. 2019 shoplifting disorderly conduct conviction. 2017 out of DeKalb. That's it.
Okay, Ms. Duncan.
Yes, Your Honor, this incident occurred over several days, actually. But it occurred at the Veranda 3. It's a property related to the Auburn Point apartment complex. This one is located at 315 Tanner Street in Atlanta. The defendant in this case had been warned on February 6, 2023 not to return to the location, and she was cited at that time and warned that next time she come back to the property, she would be arrested. The defendant returned to that property on March the 7th, And she was seen damaging the fire extinguisher housing by the property manager on security cameras. She left the scene shortly afterwards, and she came back again yesterday on March 8th and returned to that location and locked herself inside of a bathroom and would not come out. The maintenance staff at that facility had to unhinge the door to get it open so that they could detain the defendant in this case. Given her repeated offenses with this particular property after being told not to come back, we do have some concern about the risk of reoffense, given that she does have 12 cycles with several open cases. The state is going to be requesting a total $1,500 surety bond. That's $750 per count. A stay away from the veranda at Auburn Point apartment complex with the address currently stated on the record. We're going to ask for a stay away from that location, no alcohol, drugs, and weapons, and no further violations of Georgia law.
Ms. Kim?
Yes, Your Honor.
It appears that Ms. Kim has lost her connection.
The mother is actually helping out.
Ms. Kim,
Yes.
you lost your connection for a minute. So just could you start over for me?
Okay. Hello?
Can you hear me? I'm
Yeah,
here
I can
now.
hear you.
Okay, all right, go ahead.
Can you hear me?
I can hear you now.
Yes. She is 38 years old, single mother of 3 children, 2, 4, 6 years old, and she's gainfully employed at Atlanta Medical Center. She does dishwashing. She's been working there about 1 year. She successfully graduated from high school, and she does have a solid, good mailing address where she resides with her 3 children and mother. Your Honor, we would like to request for a signature on bond so she can return home and take care of her kids. I can ask for social worker services to do the behavioral health evaluation just to make sure that there's no issues, but everything else, when I was interviewing her, she sounded fine. I apologize for the noise.
Okay, given her record, it's going to be a $500 good bond per charge, a $1,000 good bond, stay away from the veranda, and no drugs, alcohol, or weapons while out on bond. Excuse me.
Thank you.
All right, and the final one is position 16, Mr. Thomas. Does he have a history?
Yeah, he got 17 total. Last arrest was 2020 for escape, interference with government property. That's out of Clayton County. He got open armed robbery, 4 counts of ag assault, 2 counts of ag battery, 3 counts of possession of a firearm or a knife during the commission. That's out of Clayton County as well. On probation for criminal damage to property, 2nd degree. That should time out in April. That's out of Clayton County. I think I saw another one of those PI charges. Hold on. 2019 probation violation. Another 2019 probation. Yes, he has a conviction for PI and sexual battery from 2019. Criminal trespass conviction 2018. 2018 failed to appear. He pled NOLO to trespass in 2017. Criminal damage to property, 2nd degree, misdemeanor possession of marijuana. He got first offender, but they ended up being convictions. That was from 2016. More probation violations and trespass convictions.
Thank you, Mr. Howard. Ms. Duncan?
Yes, Your Honor, this incident also occurred over several days. This incident occurred, it started on March the 4th with the criminal trespass where this defendant broke into the Central Library located at 1 Margaret Mitchell Square in Atlanta. And he broke into a snuck into a secured area and exposed himself to library staff. A couple of days after that, the defendant was witnessed in the parking deck behind a wall with a ski mask on. And an on-duty officer, Officer Brewer, noticed the defendant. She asked why he was there. He said that he was there to catch a ride, but he was behind the wall with a ski mask. She left the location. She went back in the parking deck. He followed her. He initially attempted to try to follow her behind a glass encasing, but he was not able to because the door was locked. She then notified her co-workers of his presence, and she attempted to go ahead and get back on the elevator. She said that the defendant followed her to the elevator and attempted to get on the elevator with her, but she refused him access. When she stepped off the elevator, she indicated that she heard a noise and she placed her hand on her firearm, and she indicated that when she turned around, she saw the defendant. Because she had her hand on her firearm, he stopped. However, he did expose himself, masturbate, and eventually ejaculate in front of this particular victim. We did make contact with her. Those are the statements that she made, and also the statements included in the warrants and police reports. She stated that she is scared and feels that if she didn't hear a noise, that this attack could have been much worse, and he could have gotten to her and done something much more egregious. We do have concerns about the risk of reoffense in this case, given that this defendant does have a PI conviction from 2019, as well as a sexual battery. And given this defendant's history with the PI and the sexual battery convictions, as well as the open burglaries and armed robberies and issues involving weapons and aggravated assaults on people, we do believe that this defendant does have a heightened danger to the community. And this particular victim, he was waiting behind a wall with a ski mask on and followed an armed officer and proceeded to do these types of actions, even though she was armed. It's for those reasons, Your Honor, we do not believe that this defendant will have a positive response to this legal process and will continue to reoffend in this nature. As for those reasons, the state is going to be requesting a $15,000 total surety. We're asking for a $1,000 surety on the willful obstruction of a law enforcement officer, a $500 surety on the criminal trespass. And let me make sure my math is correct. The additional amount is going to go to the PI charge. So if you give me one moment to calculate that, I wrote it down incorrectly. So it's 15,000 with 1,500 on the other two charges. The remainder on the PI, given that he exposed himself on 2 prior occasions. And the victim is here, if Your Honor would like to sound for her while I calculate that for the court.
And who is that? I don't know.
Jamila Brewer, my apologies. Officer Jamila Brewer is on the line.
If Ms. Brewer is with us and she wishes to address the, if you wish to address the court, Ms. Brewer, I need you to activate your camera and I'll have to swear you in.
Hello.
Yes, can you raise your right hand for me, Ms. Brewer?
Yes.
I think it's the other right hand.
I'm sorry.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, what would you like to tell the court?
You know, the situation for me is very traumatizing because I've never been in that type of situation. And for him to follow me into a garage, it was a long walkway, and for him to follow me, and when I turn around, all I see is a ski mask behind me. That's very traumatic for me. And he done been here 3 times already. And all 3 times he done something he wasn't supposed to do. So I just fear every time I go to bed or wake up, I think about this young man.
Okay, I'm sorry to hear that, ma'am. Anything further?
No.
Okay, we appreciate you being here.
Okay.
Let's see.
And to clarify the state's recommendation, my apologies, it's 1,000 surety on the willful obstruction, 500 on the criminal trespass, and 13,500 on the PI charge, given that this happened on 2 separate occasions. Nothing for, I'm sorry, and a stay away, no alcohol, drugs, and weapons, no further violations of Georgia law, and an SDET. Given that this did happen on several occasions, he does have prior convictions, the victim's statements, and the facts as alleged, nothing further.
Did we lose Miss Kim?
I think
She was kicked out because her battery died. Could you please let her back in?
Okay.
So I hope the host is seeing that.
She's not in the waiting room, Ms. Howell.
Okay. So she's not in yet.
I'll do this again when she comes back.
This is the last case, right?
Yes.
We could do it over the phone. Judge, I'm not sure what's going on, but I have her on the line. I'm willing to stand in him.
Okay. All right, so what does Ms. Kim have to say? Do you mean to be on mute, Ms. Cook?
She's 24 years old. He's been in Georgia for 7 years. Released from jail December of 22. He's not employed. We will continuously represent him. He does qualify for our services. For what? Your Honor, we're going to get the social worker involved to do, we're asking for BHEC for our client. She's requesting a signature on bond. Anything else? That's it from the defense, Your Honor.
Okay, so for the willful obstruction, it's going to be $1,000 good bond. For the criminal trespass, it's going to be a $500 good bond. For the public indecency, it's going to be an $8,500 good bond. Makes for a total of a $10,000 good bond. Stay away from 1 Margaret Mitchell Square. No further contact with Ms. Brewer. BHET, and no drugs, alcohol, or weapons while out on bond. Okay.
Thank you, Your Honor.
Thank you.
Also, I think Ms. Kim has a mental health evaluation order she needs to send to me. If you could let her know that.
Okay.
Yeah.
Okay. And I think that concludes the calendar. So Ms. Bridgewater, when you're ready.
Yes.
Okay.
Okay, once again, the reset date for the SAP calendar is going to be March the 23rd. Position number 1 is reset further notice with a $2,000 SOB through the jail. Position 2, reset further notice with a $1,000 SOB through the jail. Position 3, reset further notice with a total $4,000 SOB through the jail. Position 4 is going to the SAP calendar with a $1,000 good bond. Position 5 is going to the SAP calendar with a total $2,500 good bond. Position 6 going to the SAP calendar with a total $1,500 good bond. Position 7, reset further notice with a $2,000 SOB through the jail. Position 8 is going to the SAP calendar with a total $3,000 good bond. Position 9 is going to the SAP calendar with a $3,000 good bond. Position 10, reset further notice with a $3,500 SOB through pretrial per judge. Position 11 is reset further notice with a total $3,000 SOB through the jail. Position 12, reset further notice with a $2,000 SOB through the jail. Position 13, reset further notice with a total $2,500 SOB through the jail. Position 14 is going to the SAP calendar with a total $1,000 good bond. Position 15 took a plea. Position 16 is reset reset to the SAP calendar with a total $10,000 good bond. And position 17, I want to say we're sending this to the competency calendar for March 23rd with a $2,000 good bond. Are there any questions, comments, or otherwise?
Oh, bye.
Thank you.
You all have a good evening. We'll see you next time. Thank you.
Bye.
That's how you do it, Mr. Howard. All right, y'all take care. I'll get it back to you, Ms. Bridgewater, when you get it to me.
Thank you.
Okay. Oh.